Thank you. This is Judge Patricia Marks, who has agreed to facilitate the program tonight. She's a retired county court judge, and she was an administrative judge for the 7th Judicial District. She's very active in the community, although she's retired in some senses as a judge, but she continues to do free legal services for veterans and for other people in the community through Just Cause. And we're very happy to have her here. And she's going to introduce the panel. Thank you.
Thank you and welcome to everyone to our town hall on criminal justice and our youth. This is sponsored by the Lawyers Coalition for Racial and Social Justice. That includes a coalition of members of the Monroe County Bar Association, the Rochester Black Bar Association, and the Greater Rochester Association for Women Attorneys. The League of Women Voters is also a co-sponsor. There's a representative here. She's just waved her hand for us. And there are voter registration forms in back, and we wanted to bring your attention to that. Special thanks to Curtis Jones, and Lisa Reagan for putting this together. They've done an extraordinary amount of work. It took a great deal of time to get this impressive panel together. I'm in charge.
For those of you who would like it, the room is looped for hearing impaired, so you can link it to your hearing aids. And we do have registration forms out front and resource materials from the county for families who might need these resources after this program.
And you reminded me, Lisa, that I'm supposed to talk about the fire exits. There's an exit here, exit back here, bathrooms upstairs, 2 bathrooms on both ends of the room upstairs. And I'll continue with my welcome. I thank the New Hope Free Methodist Church for allowing us to use this venue. I think it's a wonderful venue to put our panel together. I'm going to walk you through the panel and give them an opportunity. They have 10 minutes. And these are people who could take up the whole evening. They just have a tremendous amount of experience. And I'm only going to tell you some of what they do, not all of it. And I'll introduce and give a little bio on each of them before they present, so you can keep them in order. It's a lot of information. There will be questions after. We'll take a quick break in case people need to be someplace else, and then we'll take questions. We also requested questions to be sent in by email, and Curtis and Lisa will be processing those, and then we'll have the panel answer them. So I'm going to bring your attention to the fact scenario that will be referenced in each of the speakers. You all have a written copy. I'm going to read it briefly to set the scene. This is the type of scene that people in the community have experienced, and is based on a conglomeration of cases. It's not identifying anyone in particular. So Joey's 16, and he looks at TikTok videos. He's watched several of them. He learns how to hotwire Cadillacs. So he decides he ought to see if he can really do that. He's walking in the neighborhood. He smashes a window when he finds a Cadillac. He smashes the dashboard, finds the wires, connects them, and he drives away. The car is reported stolen, and a short time later, a police officer on routine patrol sees Joey driving the car. He pulls him over, places him under arrest for criminal mischief, unauthorized use of a motor vehicle, and grand larceny. He's scheduled to be heard in family court the next day. We're going to add what may make a difference in what happens with Joey. He's arraigned by an accessible magistrate because now we're adding that a .357 Magnum is found in the car in plain view. He's charged with a violent felony offense, criminal possession of a weapon in the 2nd degree. The DA sets bail, and he's scheduled to come before the youth part. Now we're going to add another factor to the scenario just to confuse things, or actually distinguish which path they go. And I want to point out to you that up here there's a flow chart that shows how a case may be processed through the system and might be helpful in following the presentations. So now we have a passenger. The passenger is Mark, 15 years old. He's in the same vehicle. He's charged with unauthorized use of a motor vehicle. They both will have different outcomes. The 15-year-old would be picked up by the police, charged with the same crime, but may end up in the Children's Detention Center in Rush after being apprehended. The 16-year-old may be arraigned and released. And then let's complicate it further, because that's what's happening in the system. Passenger Mark is also charged with weapons, because that gun is right there in between them in plain view, and that possession is considered constructive possession. And so, first on the spot is Maureen Pollan. She's a program director for Attorney for the Child at the Legal Aid Society. Prior to Legal Aid, she was in solo practice and a member of the Children's Attorney for the Child panel in Monroe County. She's been generous with her time, presenting continuing legal education courses for Attorneys for the Child program, and is currently chair of the Monroe County Bar Association President's Commission on Access to Justice. She's been honored as one of the top women in law by the Daily Record as part of their 2024 Excellence in Law. So Maureen, tell us about the system and what's going to happen to Joey and Mark.
So when we have children or youth who are charged or alleged to have committed acts that, if committed by an adult, would be a crime, they can go to one of two courts. And which court they go to is going to depend on their age and whether the alleged acts are misdemeanors or felonies. So in the scenario that we have, Joey at 16, if we know that he's going to family court the next day, then he's being charged with only misdemeanors. Because at 16, if he was being charged with a felony, his case would start in what's called youth part. And youth part is just like adult criminal court, except we have a family court judge who sits as the criminal court judge, essentially. So if Joey's coming to family court, it's going to be a civil proceeding. It's not criminal in nature, and any adjudication is a civil adjudication, not a criminal conviction. In family court, Joey's case will be presented by an agency that's a Monroe County agency staffed with Monroe County attorneys called the Presentment Agency. And Joey would be represented by an attorney from the child. In Monroe County, the Legal Aid Society is the institutional provider of attorneys for children, so our office, so long as we don't have a conflict, is often assigned to defend children in these cases. So when we're talking about family court and alleged acts of juvenile delinquency, the district attorney is not involved, the public defender's office is not involved. Family court is the Presentment Agency and Attorneys for Children. The Family Court Act is going to apply, not the criminal procedure law, and we may borrow the terms from the penal law in terms of misdemeanor, felony, and how we define the alleged acts, but the penal law generally is not going to apply. When Joey goes to court and appears before a family court judge, that judge is going to be able to make a determination about whether Joey should be released home, probably with some court rules, even possibly with electronic monitoring, so like an ankle bracelet. Or the judge could decide that they are going to detain Joey and send Joey out to the Children's Detention Center in Rush. And the issues or the facts that the court will look at are whether it's likely that Joey is going to commit another alleged crime in the time between that first appearance and the next appearance, as well as whether it's likely that Joey is going to show back up for court. In family court with juvenile delinquency matters, there is not now, nor has there ever been, bail. So that is not something that we deal with at all in family court and have never dealt with. So in this second scenario, where Joey now has a loaded handgun, that case, because he is going to be charged with a felony and a violent felony at that, that's going to start out in youth part. As it suggests, instead of being given an appearance ticket or possibly spending the night out at Rush before going to see a judge, He is arraigned that evening, and the district attorney is involved, asking for bail. The public defender's office will be assigned in this case, in all likelihood, to defend Joey. So youth part is essentially adult criminal court. These 16 and 17-year-old defendants are going to have the penal law and criminal procedure law applied to them just as if they were in regular adult criminal court. Adjudications or convictions in youth part can result in a criminal record, and in youth part, bail applies. So there can be bail applications. And so if we add Mark into the scenario at 15, even though he's in the same vehicle, and even if he's charged with constructive possession of that gun, due to his age, he is going to be going to family court. So for the most part, children 12 to 15 are going to go to family court when they're alleged to have committed acts that, if committed by an adult, would be a crime. 13, 14, and 15-year-olds, if it's incredibly serious, might go to youth part, but almost all 12 to 15-year-olds have their cases heard in family court. As the flow chart behind me indicates, when we get to 16 and 17-year-olds, that's where it gets a little bit trickier. If they're charged with only a misdemeanor, their case is going to start in family court. If they're charged with a felony, if it's a nonviolent felony, their case may still end up in family court. And generally, when it's a nonviolent felony, there is a presumption that family court is the place that their case should be heard. And there needs to be extraordinary circumstances for a case to stay in youth part when it's a nonviolent felony. And then those violent felonies are going to be, they're going to go forward in youth part, where the consequences are essentially the same as they would be for adult criminal court. I don't think I have too much more to add at this point.
Tell us a little bit about your experience and what it takes to become an attorney for the child.
Sure. So for attorneys who are interested in becoming attorneys for the child, you have to get onto if you don't work for the Legal Aid Society or a similar organization in another county, then you have to go through a training process through the Appellate Division 4th Department in Rochester and within the counties that the 4th Department covers. It's, I would imagine, a similar process in the other appellate divisions. So it's a process of having to shadow different types of cases, go through a multi-day training, and then you also have to apply. There's an application process that goes into it. And so Linda Costin is our program director in the 4th Department for the Attorneys for Child program for the panel.
Thank you, Maureen.
Thank you.
So we're now going to go to Tremaine Harris, and he's going to tell us a little bit about what resources there are in the city for youth. Tremaine Harris has worked for the City of Rochester Department of Recreation and Human Services since he was 16 years old as a youth worker. I'm not going to tell you how old he is, but he has quite a bit of experience. He's now the Youth Leadership Coordinator in that same department in the Bureau of Youth Services. In his current role with the city, he oversees youth, Voice One Vision, Mayor's Youth Advisory Council, Mayor's Youth Academy, and I think I can go on and on. He has an educational background that includes a master's degree in leadership and organizational change from Nazareth. He's a graduate of the United Way's African American Leadership Development Program and is certified in nonprofit management from St. John Fisher. He's dedicated, mentor, advocate, and role model to youth in Rochester. So Tremaine, what can you do for these kids that are in trouble here?
All right, thank you. And hi, everybody. So I'm going to go in a different direction. So I'm going to go back to the childhood piece of the 15 and 16-year-old. So adverse childhood experiences, which is basically trauma that you receive when you're younger, whether it can be whatever trauma it is, on whatever level. And those things have a direct effect on the youth as they're growing up. So Common Ground Health in Coordinated Care Services created a report, and they did a study with teenagers all the way up until I think it was 16, and it's the effects of COVID, what it had on the youth at that age. So if they're 18, that means around COVID it was either 15, 16, and they did the study, which I have some of the youth here that was a part of that study. And what came out of the study is that being secluded for that long of a time and not having not just resources, but not being able to see your friends, not being able to go out and even go to work, school, because sometimes school is a safe haven. So all those things were taken away. And again, it's not giving excuses for what some of the teenagers do. But what it does is give you an idea of what their mindset was and what it is. And again, with that childhood trauma, some of them can't make it out of that rut that they're in. And a lot of our programs with the city, we go after the 40 developmental assets. Those are external and internal, whether it's having a caring adult, having a safe place to go, whether it's church, school. So all those different assets make up that youth. And as the study says, the more assets you have, the less that youth will be in, troubled situations. And they can still have that trauma with them, but because they have caring adults or a community, a family, a village, they're able to come out of that a little easier than some youth. So I just want to keep in mind that, yes, you might see some youth acting out, but just remember, they didn't just start acting out, woke up and say, you know what, I'm going to steal some cars, or I'm just going to rob somebody. It's Maslow's hierarchy. Their basic needs aren't being met. So some of them are out here making money to take care of their younger brothers and sisters. They have to go and cook for them, and then they get to school tired, and the teacher might say, you're lazy, you need to wake up, but not knowing that that kid is forced to be an adult in a situation that they have no control of. So we as adults have to keep in mind that when we were younger, it was a different time. And the times that they're living in with technology and other resources at their fingertip, we didn't have that. If it was a fight in school, we had to come home, call on a landline, not a cell phone, call on a landline and say what happened in school. Now, you get the video in seconds. And it does something to the youth and to their mindset. And we can go on and on about that. But I just wanted to reiterate that as an adult, we have to look past what they're doing. Don't forget what they're doing, but look past what they're doing. Let's see, ask questions. Because some youth, they'll just tell you all their business. It's just a relationship thing. But if you automatically come with negativity and not meet them where they are, and you can still hold them accountable. We're not saying don't hold them accountable. What we're saying is meet them where they are, and when they are doing something, make sure that you ask questions to make sure that you are, and you don't gotta be fully relatable. It's not about that. It's just making sure that they know that you care. That's the one thing. And a lot of these youth that are out there doing some of these behaviors, they tell us, my mother don't love me, I don't have nobody at home, so of course I'm gonna go with my friends. They take care of me. But again, they don't know. They're just living in their environment.
So what kind of help? Sorry. What kind of help can you provide to Joey and Mark? Are there services available? What if their parents came to you?
Yes, so at our Department of Recreation and Human Services, we have our centers, we have our leadership programs, our entrepreneurial programs, career development programs, and we have mechanisms for youth. Even though they might be in troubled situations, we don't turn anyone away, whether it's in recreation or youth services. And a lot of our youth come with their own trauma, like I said, and they just need someone to care. So we have many programs that we can offer. We have partnerships with a lot of organizations. So yes, some of our programs are a little high level with our leadership and different things like that, but it doesn't matter. We can still take some youth, and all the years, which has been 28 years with the city, I've seen many different versions of youth, no matter in gangs or come from a two-family home, doesn't matter. We have room for them at the city.
What about mental health resources? We read a lot in the media about teenagers and mental health resources, and it seems to be a difficult connect. Can you talk to that?
Yeah. So with our centers now, we have counselors from Center for Youth. There are mental health counselors at our big sites. I'm not sure if they're in all of them, but we do have that mechanism for that. We're also working on the mental health workshops. We got a grant from the Wilson Foundation to create mental health workshops from the youth perspective, and we have professionals that are helping them. And we have our community agencies. Common Ground Health is one of the big supporters and collaborators with the city, and not just the city, but all over. So we have many different opportunities for youth to get involved in mental health awareness programs, and we're just trying to take away the stigma of therapy. We want it natural, like I went shopping the other day, I went to my therapist the other day. So we want that normalized in the community.
Thank you. We're now going to turn to probation and Cynthia Smith. She's an Assistant Chief Probation Officer. She oversees the Family Services Division within the Office of Probation and Community Corrections. She's worked with youth and family for the past 24 years. She's received her Bachelor of Science degree from RIT and her Master's of Public Administration from State University of New York at Brockport. She served as adjunct faculty at MCC and offers her experience and guidance to students in the field of juvenile justice. I'm now going to turn it over to her to tell us what about Joey and Mark, and what's probation doing to deal with the juvenile situations that have arisen and been exaggerated by the media.
Thank you so much. One of the things that many of you may have heard about in the media is our JETS program, and that's our Juvenile Enhanced Diversion Stabilization Program. And in May of last year, our county executive made a call to action in response to the number of stolen vehicles within the county, and essentially invited several stakeholders to the table to talk about what our response was going to be as a county. And so one of the things that we came up with is to implement some changes in our processing times at probation. And so when young people are issued an appearance ticket by local law enforcement, those appearance tickets historically were taking a while to reach our probation department for us to intervene. And so what we decided was that we would expedite that process and allow law enforcement to contact probation staff 24 hours a day in an effort to hopefully mitigate the gaps that were existing between the time of arrest and service delivery. And so what we do, if it were Joey at that time or Mark at that time, really more so Mark, the arresting agency would contact our on-call probation officer if it was after hours, and would contact the duty officer during the day. And so they have access, immediate access to our officers that are on call, and that officer would begin to gather that information, find out what occurred, where was it, what were the circumstances around the arrest, and make a determination at that time through the utilization of a detention risk assessment to see if that child should be detained. And really, it's going, as Maureen was talking about, that's really based on what is the risk that this child may engage in additional acts or commit another act, or what is the likelihood that that child may not appear in court when they're scheduled. And so the officer would then provide that facilitation between the detention center if in fact it's determined that that young person should go to the detention center based on their score of 2 or above. Also, if the child is released, then that officer begins the work right then and there of trying to reach out to the parent or guardian and facilitating that conversation with local law enforcement to say that Mark has been picked up, we're calling from probation, and we're essentially trying to verify the demographics, the information, and also begin offering supports to that youth and family. The next day, those youth are seen at our probation office, so there's no lag time, if you will, between that time of arrest. If it's on a Friday, they're seen on Monday. But other than that, they're seen the next business day at 2 o'clock at the Office of Probation to begin the intake process. We begin to assess for needs and hopefully can refer that youth and family to supports and services. Some of those services include mediation or substance abuse, mental health counseling, if identified as a need. Some additional practices that we're utilizing right now are some evidence-based practices through our Boys Council, Girls Circle groups. We have our Juvenile Reporting Center, which allows for after-school activities for young people to fill that gap of time after school and give them something to do in the evenings that is positive and is structured and gives them an opportunity to build those positive peer relationships within the community. Other things that we're utilizing right in-house is we have a educational liaison through the Rochester City School District that is there on site in our office every single day, that works with us. Many of the youth that we are identifying, unfortunately, have some challenges in school. So we're working with that educational liaison to see what are the barriers. And I think the biggest focus is that we're not necessarily just looking at what occurred. We're not necessarily looking at the fact that the car was stolen and there was a weapon. While it's important, we're also looking at what led to these behaviors. And what does the family look like? You know, could we be of support to that family, whether it's basic needs, really identifying that and being a support to that youth and family. The other thing we have on site is a juvenile justice mental health coordinator that meets with children and families. The court can order a mental health evaluation if deemed appropriate. We can also, the officers can make a referral to the juvenile justice mental health coordinator for that purpose.
Thank you, Cynthia. That was very interesting. Any early data on outcomes improving because you get involved early, or is this too soon?
No, we do have some data, and we're continuing to look at the data and see to identify some gaps. But what we're finding is that those kids that that really receive our services at the onset and receive the intervention at the onset, the rate of reoffense is very low, especially while they're on that stabilization period. We just changed the stabilization period, which requires that the officers have daily contact with the youth and family. That's very important. That the officers are held accountable to have that daily contact, and the studies show that during the stabilization period, we have a reoffense rate of 1%. And even after we're no longer having that daily contact and probation is still involved, the reoffense rate is 17%.
Thank you. Next up is Judge Daryl Givens, whom I first met when he was a police officer. And he has a very interesting background, worked in the police department for a period of time, became a lawyer, and served as attorney for the children for 18 years, working for Legal Aid Society of Rochester. He was appointed to family court by Governor Hochul in 2022 and was elected for a 10-year term. He also holds additional degrees and a doctorate degree in ministry. Judge Givens, what do you think about this case? What would you be doing with this case? What is your role?
Well, my role is a constant balancing act, trying to figure out, holding the key stakeholders, the defense attorney or the prosecutor in terms of youth court, and then the attorney for the child and the presentment agency, the juvenile version of the prosecutor, holding their feet to the fire, and also trying to give time for probation or any other services to kick in and take place. So it's a constant balancing act. A couple of nuances that you may not know about family court versus youth part is that when a case comes into family court, if the youth is detained, there has to be a trial within 3 days unless there's a waiver of that for certain crimes. There are other more serious crimes where a trial has to happen within 14 days. And there's good reasons why nobody wants to have a trial in 3 days or 14 days. It takes time to get things in place. So there's a lot of adjournments, there's a lot of things that happen in order to try to get that youth the services that they need, because while all this is going on, the youth is still dealing with mental health issues or substance abuse issues and family trouble issues, and there could be other cases that the youth is involved in. There could be a neglect proceeding. There can be a person in need of supervision issue that's going on with school and truancy and all that. So it can get very complicated with some of the youth that come into court. And let me just say this about, I think Maureen Poland covered it very well in terms of the outline of family court versus youth part. But one of the things in youth part is that when the case starts in youth part for a 16 or 17-year-old, and in some instances a 13, 14, or 15-year-old who commits certain crimes, there's a presumption that the case is going to be moved to family court unless it meets a certain criteria. Some of those criteria are that the crime had to be done in a way it caused a significant injury to someone. What does that mean? It means more than physical injury, but less than serious physical injury, something in between that. Quite honestly, the court is still trying to figure out what that means. But anyway, that's one criteria. The other criteria is that they have to display a deadly weapon in the furtherance of a crime. And that usually is a gun, but it could be some other things that could be used. And then the third thing is certain sex crimes. Even though it's a violent crime, if it doesn't meet one of those three criteria, it's presumed that the case is going to go to family court. But the district attorney could make a motion to try to keep it into the youth part. And I heard Maureen mention extraordinary circumstances. So basically that is when it doesn't fit those categories, but the DA thinks it should stay in youth part because of some extraordinary situation. So that's one nuance that people may not know. The other thing is that there's always this, in either system, there's always this presumption of release. And so a lot of questions I get is, well, why do they keep releasing all these kids? And they're doing all this stuff, and keep them in, you know. But the law, and either in family court or youth part, there's always the presumption of release. And when law enforcement or probation gives somebody an appearance ticket, and they actually appear, the appearance ticket has done what it's supposed to do. You want people to appear in court. And so I say all that to say that the judges are limited as to what they can actually do, limited by law. So, and also we're not on one side or the other. We're trying to overview the whole case. So it's a constant balancing act. It's trying to give everybody their constitutional rights, trying to make sure that each side is heard equally, but also trying to give time for the youth to be able to get the services that they need. And I commend probation. I was just telling Deputy Chief Smith that they do a fantastic job, and I don't think many people know exactly what they do behind the scenes, but I work with them all the time, and thankful to have them there.
You're in a unique position. You've had an experience as a police officer, attorney for the child, and now a judge. What do you think is the biggest asset you bring to the bench because of those prior experiences?
I think that I bring a diverse experiences. I've been on all sides of it. So as a police officer, I've unfortunately had to arrest youth and also work with youth as a police officer. I've also defended youth as an attorney for the children. And now as a judge, I'm overseeing these cases. So I think that I've seen all the different aspects of it. And you just get a real appreciation for the youth that come in and their families, because there's a lot more to the story than just what you see at the podium. There's a lot that's happened before they got there. And so I'm always humbled by that and try to remember that there's more than what we see.
Thank you, Judge. So now we come to Michael Green, and he probably doesn't need an introduction. He's run for DA twice. He's been DA for 2 terms. Prior to that was an assistant district attorney. He also led the New York State Division of Criminal Justice Services from 2012 to 2021. He is currently a visiting assistant professor at Rochester Institute of Technology, Department of Criminal Justice. He's involved in a lot of research related to criminal justice issues. And while he won't be directly speaking on issues of juvenile crime, we thought it was important to hear about his research because everybody thinks that bail reform has to do with these kids that are stealing cars, and that bail reform affected that. And the reality is it did not. And there's also some data regarding bail reform. So at this time, I'll turn the mic over to Mr. Green.
Thank you, Judge. And it's nice to be here with the panel. I go way back with Judge Givens. He wasn't just a police officer, but he was an investigator in the homicide unit working on some of the most serious cases that they had, and did a great job. And I have a lot of respect for all the panelists who are, really on the front lines of the system dealing with the cases. I was in that role for 25 years. I now have the luxury of being a little removed from the front line in my role at RIT. But as I said, I have a lot of respect for people who still are on the front lines doing the hard work. And I think as the judge indicated, when I was asked to speak on bail reform, the first thing I said is, well, you're talking about juvenile issues where bail, as Judge Givens said, really isn't an issue. So I don't know that you want me to speak. And they said, no, we really do want you to speak. And I think as Judge Marks said, oftentimes we hear things put out in the media and the public about why we're having crime. And when we saw shooting rates go up during COVID and George Floyd, right away we heard, well, it's bail reform. When we saw stolen car cases go up after social media put out things about Hyundai and Kia. We heard, well, it's raise the age or it's bail reform. And I think it's really important to look at the data and really understand, are those the things driving it or not? Because if they're not, and that's what we're blaming, we're missing the true solutions, like some of the things that we heard about today. So I'm going to talk about one of those issues in particular, and that is bail reform. And I think there's a few things to keep in mind that are very important when you think about bail reform in terms of why we had bail reform. And the first is that the United States incarcerates, in terms of rates, probably more people than any other country in the world. We have 5% of the world's population. We have 25% of the world's incarcerated population. And our rates are astronomically higher than Canada's, than European countries that we might want to benchmark ourselves against, even than Mexico. And in addition to having incredibly high incarceration rates, the racial disparity in the system is incredibly high as well. If you look at New York, for example, in New York State as a whole, 15% of the population is black. 39% of the adults who are arrested are black for felonies. 45%, I'm sorry, that's all overall arrests. 45% of the adults arrested for felony offenses are black, and 51% of the adults sent to prison are black. So 15% of the population, 51% of the people sent to prison. And if that wasn't bad enough, if you look at New York City, blacks make up 22% of the population, 49% of the arrests, 52% of the felony arrests, 61% of those sent to prison. And it gets even worse when we look at Monroe County. Monroe County, black people make up 14% of the population. They make up 49% of adult arrests. They make up 54% of felony arrests, and 70% of the people sent to prison in Monroe County in 2022. So 14% of the population is black, but 70% of the people we sent to prison in Monroe County were black. Now, I say that not to disparage any individual actors in the system. I don't believe that the underlying problem, or one of the main drivers of the underlying problem, is people in the system intentionally discriminating. I do think that we have structural problems with the system, and I think the legislature felt the same. I think when the legislature passed the reforms to the bail system, they were concerned about mass incarceration, they were concerned about racial disparities, and they felt that we had a structure or a system which created those results. They didn't happen by accident. And one of the things driving those was the idea that we used the amount of money that somebody had to decide whether or not they got held on bail or whether or not they got released. And as we all know, in our society, unfortunately, the amount of wealth you have and the color of your skin are not unrelated. And in the areas where we have significant crime, we have higher percentages of people of color, and we have much lower incomes and lower access to wealth. So, people, and particularly people of color, are disadvantaged if we're going to use how much money you have to decide whether or not you stay in jail while your case is pending. And that decision is not divorced from the other results in the system. Data shows that people who are held pre-trial are more likely to be convicted than people released on bail pre-trial, and people who are held pre-trial are more likely to be sentenced to incarceration than people who are released pre-trial. So these things all have effects all the way through the system, and the legislature, in enacting bail reform, was trying to do something about those factors. It's also interesting to note that not only do we have a system of cash bail, which creates injustices in and of itself, but we are one of only 2 countries in the world that allow private business to profit off of that system. And basically that's the bail bond industry, and it's the US and the Philippines. They're the only 2 countries in the world that allow private businesses to profit off the system of bail. And it's a big business with a lot of money and a lot of profit. And so bail reform, again, was a way to try and get at that issue as well. And one of the things bail reform did, and I won't go into the details because we don't have time, but in a very simple way, it said for misdemeanors and nonviolent felonies, if you're not on probation, if you're not on parole, if you're not a repeat offender, you get released. You can get released with conditions, you can get released outright, but we're not going to use the amount of money you have to decide whether to hold you or not. And in looking at what impacts that had, it definitely resulted in fewer people being held in jail. In New York, in the state as a whole, in a given year after bail reform, estimates were that the state saved somewhere between $70 and $80 million as a result of fewer people being held on bail. In Monroe County, that estimate was somewhere in the neighborhood of $2 million. In this, there was a paper that I wrote as part of the, that's attached as part of the materials where you can get more detail on this. So if we're saving money and if fewer people are being held, then the question is, are there negative impacts? Is that driving crime? We can all come up with anecdotes. I practiced for 25 years, and I can give you anecdotal cases of people long before bail reform who got arrested, got released, committed new crimes. The question is that happening more after bail reform, or is it not? Is it happening the same? And there were studies done by the Mayor's Office of Criminal Justice, by the Albany Times-Union, by the New York City Controller, by the New York State Division of Criminal Justice Services, by FWD.US, by the Data Collaborative for Justice. And all of those studies came to the same basic conclusion, and that was that there was no statistically significant change in rearrest rates before or after bail reform. The Brennan Center did an interesting study looking at this nationally, and they picked 22 cities nationally where bail reform had been enacted, and they picked 11 cities that did not have bail reform, and they compared the crime information in those 33 cities. And what they found was there was no statistically significant connection between bail reform and crime rates. In the argument, they concluded that bail reform is driving crime, takes away from or distracts from the real solutions to our crime problems. And if you look, again, there's not a single analysis in New York to date that has linked any increases in crime to bail reform. You can look, for example, at the shootings at things like COVID and the trauma that COVID caused and the disruption it caused. You can look at TikTok and social media in relation to stolen cars, but bail or raise the age for that matter, there's no studies showing they have any connection. So what I would leave you with is this, that before we call to roll back any reforms, including bail reform or raise the age, given the positive impacts, we ought to be certain, and we ought to demand from people making those calls that they show us data proving that there's a connection between that and some problem we're trying to solve before we roll back the positive impacts those things have had.
Thank you. It's really important that everyone here spread the word about that information and challenge the media to report the facts. There are stories here that are compelling and that the press ought to cover more than people blaming things that have no connection. I will tell you we're recording all of this, and it's available through the Monroe County Bar Association, right, Kevin? So if you contact mcba.org, did I get that right? You can show it to friends, have meetings, have parties over it. Let people know. I think this is an important message, and everyone at this table in this panel discussion has worked really hard to make a difference and to provide information that's really important to the quality of life in our community. And it needs to be supported, and it needs to be supported in a meaningful way. I don't know if any media is here, but mainstream media likes to put things on that are less complicated and therefore don't go into the details. and the facts that are needed to understand the system. And when they challenge the system that way, we lose respect for the system, and that's not a good thing. So I'm going to challenge everyone here to do that. We have an opportunity for questions. We're asking that you write them down first. We're going to take, 5 minutes? Lisa? What's my charge? Tell people, like, 4 or 5 minutes in case you have to use the bathroom. Remember, the bathroom's upstairs. I hope we can cut that part from the video. And we'll take a 4 to 5 minute break.